Hello, my name is Maureen White, and I'm an attorney with South Carolina Legal Services. I'm actually the lead attorney, and I assist with working with other attorneys in our bankruptcy cases, both large and small. And today's topic is, what is bankruptcy? It would be an entire session could virtually be dedicated to what is bankruptcy, because it's been in history going back as far as the pre-revolutionary days. But I'm going to limit this to what is bankruptcy for those of us today that experience severe debt problem. First off, I do want you all to know, though, that bankruptcy has been authorized through the Constitution at Article 1, Section 8, and this article gives Congress the power to enact legislation pertaining to bankruptcy. I say this only because it shows the importance of bankruptcy law and the importance of understanding that is a remedy that was perceived many, many years ago as a safety net for consumers and businesses alike. Today we are practicing under what's considered the 2005 Act of Congress, which is our most recent bankruptcy code. Some things that we need to know about bankruptcy is that the bankruptcy court is a federal court. It is a court of full and absolute disclosure. Nothing can be kept secret. Nothing can be hidden. An attorney can't know something and not disclose it to the court. So it's not something that everybody wants to pursue, because there are no exceptions to the disclosure requirements. In addition, it is probably one of the only civil remedies that has criminal penalties attached should you not follow the rules. You are asked to swear under penalty of perjury that everything you say in court is accurate. You're asked if everything you told your attorney was under penalty of perjury. You're asked if you signed documents understanding that everything was with the understanding that it was under penalty of perjury. So I start with that not to scare you, but just to make it clear that it is not a remedy to be taken for granted, but one to be pursued seriously. We often say that bankruptcy is for the unfortunate yet honest debtor. Unfortunately, circumstances have caused them to come to the court, but it is not because they were not honest in their incurring of debt and getting themselves into circumstances that they can no longer get out of without the court. It is a remedy which is beneficial to most, but it shouldn't be the first remedy somebody seeks if they get into debt problems. It's kind of like the quicksand. Can you jump over the puddle by just walking around it, jumping over it, or are you so stuck in the quicksand that the only way to get out of it is to seek the protections of the bankruptcy court? Once you've concluded that you have virtually tried everything within your power without compromising your health, safety, and your family to deal with creditors, then you are in a position to talk to a bankruptcy attorney and consider bankruptcy. It's a lot of work. You will not like how many questions you have to answer for your attorney. You will have to attend a course which is called credit counseling, which is actually good. It causes you to reflect on your income and your expenses. You have to allow your attorney to review your bank statements, tax refunds, tax returns, payroll, debts. It's a very involved process at the front. Once you've done all the work and you and your attorney have sat down with it, the hearing becomes quite easy. So why would we want to file bankruptcy? We know that it's debts, but what kind of debts are what really cause us to seek the protection of the bankruptcy court? If your property is at risk, whether it's your house, your car, furnishings, you want to consider bankruptcy. Is your income at risk? Do you have a Social Security overpayment that's taking money out of your Social Security check? Do you have a tax debt that's over 3 years old that's garnishing your paycheck? Is your survival at risk? Are the calls just completely preventing you from enjoying any part of life? Are the lawsuits costing you money, and loss of hours at work? Are the judgments virtually putting liens on your property, making it of no value? Is your job being affected? Are you getting calls at work that won't stop? Employers know this. Have you lost a spouse and your income was just cut in half? Have you just escaped domestic violence and you don't want to have to go back to the abuser to try to get debts taken care of? These are just some examples of situations where you really need to seek bankruptcy protection to alter the situation for the good and permanently. As soon as you file bankruptcy, a stay is imposed, which stops all collection, all garnishment, all harassment, all phone calls, all letters. It allows you to think and reorganize and pursue what is often called a fresh start. There's two different kinds of bankruptcies, and we're not going to get into those at this time, but I'll call them the sprint and the marathon. The Chapter 7 is a sprint, and if your debts fall within certain types of debts, then you would want to seek a Chapter 7. If they do not, and it involves protecting homes and cars, then you would want to seek a 13. And I call that a marathon because completion of it will take anywhere from 3 to 5 years. Both are wonderful remedies to overwhelming debt, and each has its own purpose, and each situation needs to be evaluated to determine which chapter is appropriate. So I encourage you to examine your debts, examine your ability to take care of them on your own, your likelihood of succeeding in taking care of them on your own. And then if all else fails and you just know that there is no other option, then you're encouraged to consult with a bankruptcy attorney. Thank you.